When a couple separates, they typically need to divide their assets, which can pose some issues, especially if you're not on good speaking terms. So tell me, Diane, how can assets be divided when things aren't going so well?
Look, that's a really hard one to answer, Bree, because if people are not on good speaking terms, then it's often the case that if they meet to resolve their dispute, then they may get sidetracked and talk about those things that aren't really the big issue. So really, if they're not on really good speaking terms, perhaps they can consider a couple of options, such as lawyers' correspondence, engaging a lawyer, and also shuttle mediation. There are some mediation centres around that may do a mediation, which means that they both attend a centre, they're in separate rooms, and there's a mediator that goes between them both. However, if they're able to negotiate between themselves and speak and not be able to get sidetracked, that's best for them. Because ultimately it means that they've reached an agreement together, though there are some things that then have to be considered, but they've reached an agreement together, and importantly for them, it also would reduce their legal costs because there's not correspondence being written.
So how can they minimise the costs, I guess?
Well, a couple of issues. They need to be ready. So when they come to an appointment, for example, bring financial material. Even if they think it's not relevant, the lawyer will be able to generally say, look, we don't need that, or I need this. So bring documents that are relevant to the financial circumstances so all information can be obtained, and then they are informed and they can then go away and have a discussion if they can, or if they can't, they may wish to engage lawyers, or they may want to write to their ex as well, because they can do that as well.
So let's just say they have reached an agreement either through lawyers or through working out themselves. What's the next step after that?
Look, you should always formalise your agreement to protect yourself and protect your assets. No handshake deals. Any agreement should be formalised through what we commonly refer to as consent orders. These are a binding court order in terms of what the agreement says, which will say essentially who gets what. So if you need to be reasonable though in reaching the agreement. It still needs to be a fair agreement. It can't be that one person gets everything, the other person gets nothing. Although in some circumstances that may be fair. So it's really one of those things where they should formalise it. They should make sure it's in a binding document, and they should of course get legal advice on the document to ensure that it is fair.
Yeah, love it. So let's just say all the property's in one person's name. What happens there?
So often people think it's in my partner's name, so it doesn't form part of the property pool. That's just simply not true. Even if you do not legally own any of the property, it will be included in the property pool, because the first step in any property settlement proceedings is to ascertain the assets and liabilities. And all assets and liabilities that exist at that point will form part of the property pool. It doesn't matter if it's in one person's name or the other's name, and the assets include superannuation as well.
So working out what you've got and what you owe can pose to be difficult in the midst of a separation. So to ensure this gets sorted out properly, definitely do yourself a favour. Consult a family lawyer like the team from Ruhl Family Law. Come see Diane, she'll help you out.